Welcome to Reed Smith's webinar on Pennsylvania and New Jersey sales tax on software and related services. I'm David Gutowski. I'm a lawyer here with Reed Smith. Joining me today is Rob Weyman, another lawyer here at Reed Smith. Like me, Rob is licensed in Pennsylvania and New Jersey. And Rob, why don't we start with Pennsylvania? And there's been some developments there. What do taxpayers need to know?
Okay, thanks, Dave. We're going to talk first about Pennsylvania. We're going to focus on kind of three categories. First, we're going to talk about software, kind of canned and custom software purchases. Then we're going to talk about recent expansion of the sales tax to digital goods and what that means. Then we're going to talk about services related to software. And then capping it all off, we'll talk about sourcing those three categories. So first, starting with canned software, there's been two cases in Pennsylvania. Deckert and Graham Packaging both found that canned software is the sale of canned software is a sale of tangible personal property, and if it's sourced to Pennsylvania, it's subject to Pennsylvania's sales and use tax. So there's no question really that software is taxable. What has been surprising taxpayers at audit, and oftentimes when they see tax charged on their invoices, is Pennsylvania's expansive view of what a sale of canned software can be. It's not just getting a software program on a disk or a download. Pennsylvania has been expanding the definition of canned software to include really any service where you, as the purchaser, have some sort of access or control over the vendor's software. So if you log into a website for a software as a service purchase or an information service purchase, but you log in and you send queries, for example, to the server of the vendor, the Pennsylvania Department of Revenue has been taking the position that that actually is not the sale of an information service or software as a service, it's the sale of access to the vendor's canned software, and they've been issuing assessments or guidance saying that those sales are taxable. It's somewhat similar to the Michigan litigation around Thomson Reuters that was litigated several years ago, but actually even more expansive in the sense that any access of the vendor's software is taxable.
So even if you're not downloading something, if you're merely logging in to a website, entering in your password, as long as you do something that controls the server on the other end, Pennsylvania's taking the position that that's taxable.
Yeah, we even have an assessment appeal now, actually, where there's not even a login really on the purchaser's side. There's a data transmission that they send to the vendor. The vendor's servers process it and input their own information, send back a result, and that's been assessed as the sale of software. Even though it's categorized as a service in almost all any other state and in all the kind of vendors' materials. So it's catching a lot of taxpayers by surprise. It's something to look out for at audit. Along with kind of the expansion of kind of what is software, the legislature in August 1st, 2016 had put into effect legislation that taxes digital goods. Digital goods are commonly taxed in other states. They're often thought of as kind of e-books, ringtones, music downloads. There's also a tax on streaming services that is included in the expansion. There's expansion of the sales tax. So there's 10 enumerated goods, and there's a catch-all provision in the expansion of the sales tax that I think has caught a lot of taxpayers off guard. Pennsylvania included in the definition of tangible personal property any sale of what is called otherwise taxable tangible personal property that is electronically delivered, streamed, or accessed. And it was kind of unclear what that meant, but what the Pennsylvania Department of Revenue is asserting is that language can be used to tax what other states would consider information services. So there is no explicit tax on information services in Pennsylvania, but this catch-all provision is being used to tax them. So for example, if you purchase online access to tax research or a statutory code, Pennsylvania is viewing that as something that in a previous form would have been sent to you as a book or in printed matter. Now you're accessing it online, and they're saying it's subject to tax. So it's kind of been a backdoor way of taxing information services.
Is there a true object test that could be applied here? If what I'm after is just the information, I don't care what form it's in. Back in the day when you get CCH, I wanted to have that book. But nowadays, there's information that I want. I don't care how you get it to me, as long as I, get the information. Does that matter?
According to the department and its rulings, no. And actually, the big difference is obviously at the end of the day, when you got a book, a tax-free CCH book, you couldn't type into the book, I'd like to find everything related to these search terms. So you are kind of buying something different today. You're getting additional services than what you were able to get when you just got something in a tangible form. And the way the department's kind of gotten around that is they said, well, even if that's a service, they go back to the software definition. And they say that those search queries are actually purchases of software. I think there's a real opportunity here. I think this is beyond the statute, so you're going to see vendors following the department's guidance charging tax. So there's going to be refund opportunities for Pennsylvania-based purchasers. But on the flip side, you really have to be prepared for your next audit. Starting August 1st, 2016, the department auditors are going to start looking at those transactions, information services and similar types of transactions, and possibly characterizing them as taxable. Finally, services to software. So this is kind of our third bucket. Software maintenance, the department has taken the position is taxable under the Deckard and Graham packaging decisions. Before August 1st, 2016, there's a position that it's not. After August 1st, 2016, software maintenance is added into the statute as taxable. And then there's a question of what does that mean? So the department has issued some guidance on this. They've indicated that typical software maintenance contract that includes help desk support or call center support, they'll say the entire maintenance contract is taxable because they're claiming that software support in the form of kind of IT help desk is taxable in Pennsylvania. I think there's a real question about that guidance. If you can carve out kind of a call center, or you think of your typical IT help desk. You call up and you say, my software's not working, and the person says back to you, well, did you try turning off your computer? And you turn it off, and you turn it back on, and it starts up again. That help desk really doesn't do anything to your software. They're not logging in, they're not fixing anything. So there's a real question of those types of services would be taxable.
Yeah, I have a real problem with that. I mean, if I have my car, maintenance done on my car, I want to drive my car in and drop it off, and I'll come back later. But if I have to drive my car there, and then some technician tells me, how to flip open the hood and start messing around with the wires, I don't view that as maintenance.
Yeah.
I view that maybe as some sort of learned service, but unless they're touching the car themselves, or in this case, unless they're touching the software themselves, I don't see how that can be taxable under the statute.
Yeah, and I think there's some confusion in the language. There is this kind of reference to support in the statute, but there's a long statutory analysis that you can go through that makes it fairly clear that that is not intended to tax support in the sense of kind of a normal IT help desk. So there's a real opportunity there as vendors start following the rulings to claim refunds.
And I guess in our experience, we're seeing vendors complying
Yes.
with the department's policy, because if they don't, then they're on the hook.
They get assessed, so they have to follow the policy. Finally, flip to kind of two alternatives. So say you have a taxable purchase, sourcing and exemptions. Pennsylvania has had kind of flip-flopping rules on how you source software. Prior to 2012, software was sourced to where it was located. So if you had software on a server in Pennsylvania, but you used it outside the state, it was sourced to the server location. It was taxable in Pennsylvania. In 2012, that was flipped. Now,
And no statutory change. I mean, just they woke up one day and decided to completely go with the opposite rule.
there was absolutely no statutory change. Just completely reversed course and actually issued a new letter ruling, and that letter ruling says you source software based on where it's accessed. So if you have a user in Pennsylvania, even if the software is located outside the state, it's still taxable in Pennsylvania.
And as far as which of those two rules is the correct one, I mean, there's been no case law on that yet. Has there been any administrative rulings of the Board of Finance and Revenue that picks one or the other?
Yeah, the Board of Finance and Revenue will follow the 2012 guidance. If you can provide, so there's been a lot of refund claims filed by Pennsylvania-based taxpayers that had software sourced here based on kind of billing address, but actually a lot of the users of the software were located outside of Pennsylvania. And the Board of Finance and Revenue has been taking the position, if there's sufficient evidence of that, to grant refund claims. So they've been following the 2012 ruling for periods after 2012.
So in general, it's a good thing for companies that are based or have a lot of activities in Pennsylvania. They can move some of their tax cost out of Pennsylvania, whereas companies that maybe have the servers outside of Pennsylvania but have some employees in Pennsylvania, those are the ones that are really finding that they're having to pay more Pennsylvania tax as a result.
That's right. That's absolutely right. And I think going forward, the letter ruling addresses kind of cloud computing and SaaS software, but I think the same sourcing analysis should apply to digital goods and services to software. The only other thing just to keep in mind, if you have something that Pennsylvania has very broad exemptions for manufacturing and research and development. So if a service is recategorized as a sale of software or a taxable sale of maintenance, services and tangible personal property are both eligible for those broad exemptions. So if you're in those industries, there's a lot of opportunity to claim an exemption, even if it would otherwise be taxable as a sale of TPP. And with that, let's turn it over to New Jersey, which kind of serves as a kind of great contrast to Pennsylvania's very kind of expansive tax on software and services. New Jersey kind of goes the other way.
Right. So for New Jersey, there's a statutory definition of what tangible personal property is, and software is included in that definition. Now, the difference from Pennsylvania is there's an exemption. There's an exemption if you're a business, you get electronically delivered software. That software is going to be non-taxable. So as long as you can get electronically delivered software, you don't have to worry about sales tax on your software purchases. If you need to have a disk, there's still some options there. If you receive multiple disks, then you can essentially carve up the liability into the multiple states where the vendor ships the disk. And there's really not a lot of guidance on how you break up the purchase price, but if you have multiple disks and only one of those goes to New Jersey, then only a pro rata portion of that software would be taxable, even though you're receiving a disk in New Jersey. Now, the better option is if you need to have a disk, have your server outside the state, because if the software is loaded on a server outside of the state, even if you receive a disk, it won't be taxable in New Jersey. It's treated the same as electronically delivered software. Now, services, that's where New Jersey's another difference with New Jersey compared to Pennsylvania. First, with respect to software as a service, not taxable at all. It doesn't matter how much control you have over it, non-taxable, just like electronically delivered software. As far as services go, services are taxable in New Jersey. Installation services and repairs, those things are taxable in New Jersey. However, the scope of what is and what isn't taxable is provided for by regulation. And the regulation provides a very narrow rule with respect to the taxable scope of repairs and installation. Essentially, as far as installation goes, the regulation provides that if all you're doing is dragging and dropping software, from the disk onto the hard drive, or from a remote drive to a flash drive to your hard drive, that's the only thing that the regulation allows New Jersey to tax. Any configuration or modifications to the software, that's going to be non-taxable. Now, repairs are taxable. Repairs of tangible personal property, absolutely taxable. But what is a repair with respect to software? In general, if your software is not working, you're not going to take it back to the same, the same form it was in when you first purchased the software. Software continues to improve over time. So to the extent your software is patched or improved, or modified to make it work better, that service is not taxable. It's only the act of fixing something that's broken and putting it back in the same form that it was when you got it that would be taxable. And again, these are rules that are provided by the regulation itself. They may be inconsistent with what the auditor is doing because the division's historic policy, it did change over time. It did narrow the scope of what is and what isn't taxable as far as services go. But in our experience, we see that auditors are still applying the same rule that predated the regulation. So, look at your purchases. If you're paying tax on the full amount of software services, or if an auditor is trying to assess tax on the full purchase price, you're paying too much. Now, a trick with the trick is showing the portion attributable, the portion of the purchase price that's attributable to each component of the service. And that's where it can be difficult. If you're going back in time, you have a service purchased in year one, maybe 4 or 5 years before you get audited or before your refund claim, gets considered. If you can get contemporaneous evidence, that's going to be the best thing. You want to show itemized charges, in the contract or on the invoice, and you want to retain that in your audit file as best you can. If there's any sort of other information you're getting from the vendor, again, contemporaneous evidence is better. And that goes for the electronic delivery documentation as well. We've seen time and time again where a purchaser gets some sort of software, it's electronically delivered, but the invoice or the contract isn't crystal clear.
The contract always says, either right. Electronically delivered or disk. Yeah. And
to try to show that after the fact can be very difficult. And even where you get statements from the vendor, saying, that's how it was delivered. We've had auditors who dismiss that sort of evidence as self-serving. Now, those are things that you can, appeal, further up the chain and get relief on. But the best thing is to have something on the invoice or in the contract itself. Especially if your vendors go out of business, and software vendors go out of business routinely, or you're not working with them and they're not inclined to help you out anymore. Get it up front, keep it in your audit file. Just to help taxpayers understand what is and what isn't taxable. The materials we have, some Venn diagrams, if you might remember back from elementary school, what is and what isn't taxable. And you'll see that the scope of what is taxable is really quite narrow. And it's certainly worth looking at your typical contract to see what portion falls within the taxable piece. As far as the equipment itself. Laptop servers and storage services, tangible personal property is going to be taxable. So your laptops and servers, in the ordinary course of things, will be taxable. Although there is, manufacturing exemption, research and development exemption that you can apply to that sort of equipment. The research and development exemption, it's a separate exemption than the manufacturing exemption. In Pennsylvania, manufacturing exemption, and in New Jersey, you just need predominant use, 51% of the time. Then even if 49% of the time you're using it to surf the web, that computer is going to be non-taxable because it's predominantly used in manufacturing. Research and development in New Jersey, in order to qualify there, you need 100% use exclusively in research and development. So, if your scientist is doing their thing, then come Cyber Monday, they're surfing the web, seeing what they're going to purchase, on sale. It's that sort of thing that can get you into trouble. But as long as you've got exclusive use, you can qualify for an exemption. As far as servers go, even easier, if you outsource your server function and do web hosting, data hosting, that's completely non-taxable. Even if it's a dedicated server, as long as you don't own the server, it's going to be a non-taxable service. If you own the server, by contrast, then if you hire somebody to keep that server in a secure location or in a special location that has cooling and electricity and that sort of thing, that's going to be taxable. So if you own the server, taxable. If you don't own the server, non-taxable. Moving on to information services. Unlike Pennsylvania, New Jersey actually has a statute that provides for the taxation of information services.
Imagine that.
Right, and New Jersey's rules, it's a lot like New York's rule. Essentially, if you're buying information, and it's not your own personal information, if it's out there from the public domain, then that's going to be taxable. Where you can get into trouble is sourcing. If you receive that information, let's say it's emailed to you, and you receive that email in New Jersey is going to apply tax to the whole purchase price, even if you can use that in other jurisdictions. There used to be a multiple points of use exemption right in the statute. It's been removed, so now it's more difficult to only pay tax on the portion of the service that's really for information used in New Jersey. The best way to get around it, you still can argue for multiple points, but an easier way to cause less headache is to receive the information in a state that doesn't tax it. I guess we used to say, receive the information in Pennsylvania and only, send the portion of information that's used in New Jersey, to your folks in that state. But now, you have to pick a different state. New Jersey then would only require you to pay use tax on the portion of the information that's used by your employees within the state. You should also watch out for bundled software. If you're receiving information and as part of a single charge, you have access to some sort of proprietary software to view or analyze the information, you can get hit with tax on the full thing. You ought to work with your vendor to split off the two pieces. To the extent that the software portion is electronically delivered, you wouldn't have to pay tax on it, and you'd only have to pay tax on the portion of that information service that's actually used in New Jersey. And then finally, with respect to New Jersey digital property, like Pennsylvania, they're going to tax books and records, music that you download. If you merely stream it, not taxable. If you download it, it is taxable. You can apply the research and development exemption to digital property, not the manufacturing exemption, but you can if you're downloading journals, for example, medical journals or scientific journals that are used by your researchers. Those can be used. You can apply the research exemption to avoid tax on that sort of thing. And that creates a little bit of tension between information services and digital property. If you're using information services and research activities, that's still taxable. But if you can construe what you're receiving as digital property, then it wouldn't be taxable. So you might be better off downloading the information as opposed to getting some other sort of information stream. So that provides a summary of New Jersey and Pennsylvania. What are some of the takeaways that taxpayers should go back to their office with?
So I think for Pennsylvania, the key takeaways are going back and looking at purchases of information services, software as a service that were sourced to Pennsylvania, and take a look at whether or not your vendor has been charging tax following department policy, in which case you might have a refund opportunity. Or on the flip side, if they haven't been charging tax, preparing yourself for audit, preparing yourself to show that you do not fall within kind of the department's broad application of what either a sale of canned software is or what a digital good is under their kind of provisions, under their kind of interpretation of the statute. And then I think also taking a look at sourcing. If you're a Pennsylvania-based company, you have software maintenance support sourced to Pennsylvania, but it's used by your employees around the state. There's a real great opportunity to claim a refund, around the state, around the country, on the percentage of use outside of Pennsylvania, even if it was originally sourced here. Those are the two big opportunities, I think.
Yeah, I think the takeaway from New Jersey is that really you shouldn't be paying that much tax on your software-related purchases in New Jersey. The software itself, as long as it's electronically delivered, should be non-taxable. And even if you do get some disks, there are ways to minimize the portion that would be taxable in New Jersey. Same thing with information services. And as far as services to the software, as we discussed, for the most part, that stuff is not going to be taxable. It's really just a small subset of the overall service that's going to be taxable. So again, work with your vendors to pay the right amount of tax in the first instance, file refund claims if you've been overcharged. One word of caution though, as far as refund claims go, New Jersey does participate in retaliatory audits. So if you do file a refund claim, even if it's a single issue refund claim, a small dollar amount, you should expect to get a full-blown audit that's going to cover sales and use tax, other withholding taxes, and maybe even income tax, shortly thereafter. So, if it's not a lot of dollars, you might want to, work with your vendors on kind of a go-forward strategy as opposed to filing refund claims. And I think Pennsylvania as well is now moving to the retaliatory audit world. So again, you want to be cautious before you file refund claims.
Yeah, effective April of 2017, Pennsylvania, refund claims, typically if it's over $100,000, they are going to issue an order sending it back to audit for an audit of the period for sales and use tax. So it's worth, making sure that you've analyzed your potential exposures before you file a refund claim if you're not under kind of routine audit in Pennsylvania.
Okay. Well, that concludes our program. We thank you for joining us, and our contact information is provided as part of the materials. Feel free to contact either one of us if you have any questions, need any information, or if you're curious about any of the letter rulings that we referenced. We're happy to discuss and share with you. Thank you.